Forget what you've been told about the constitutional limits of the executive branch or the political theater of the campaign trail. This is not about campaign rhetoric or televised debates. This is about a specific mathematical fracture in the American trade architecture that just opened up in a federal courtroom, and it carries a $166 billion price tag. While the mainstream media spent the last 48 hours dissecting poll numbers, a group of federal judges just reached into the engine room of the global economy and pulled a fuse. They didn't do it with a speech. They did it by questioning the very foundation of how the United States levies taxes on its own citizens under the guise of national security. The math is cold, the implications are structural, and if you are currently holding assets in a 401k or running a business that relies on a global supply chain, the ground beneath your feet just shifted. What we are witnessing is the potential collapse of Section 301 of the Trade Act of 1974, the specific legislative hammer used to build the wall of tariffs against China. This story is not about whether you support or oppose Donald Trump. It is about a massive, multi-year legal offensive launched by over 6,500 American companies, including giants like Tesla, Ford, and Target, who are demanding their money back. I am going to show you how a looming Supreme Court decision could force the U.S. Treasury to issue the largest refund in the history of global trade, effectively bankrupting the central pillar of the America First economic strategy. We are talking about $166 billion in collected duties that the government may have to hand back to the private sector because they violated their own administrative rules. Stay with me. If you're new here, subscribe to Daily Brief right now. Hit the notification bell because in the hours ahead, this story is going to move fast. And the markets are not yet priced for what happens if the U.S. government is forced to write a check for $166 billion. Let's go back, not to the last election cycle, but to the summer of 2018. That was the moment the Trump administration invoked Section 301 to begin the systematic decoupling from the Chinese economy. At the time, the narrative was simple. We tax their goods, they feel the pain, and American manufacturing returns. But inside the room 400 of the U.S. Court of International Trade, the warning signs were already flashing. The U.S. Trade Representative, or USTR, was moving with a speed that many career bureaucrats warned was procedurally reckless. By the time the administration reached List 3 and List 4A of the tariffs, they were no longer just targeting technology transfers or intellectual property theft. They were taxing everything from vacuum cleaners to baseball caps. Bloomberg reported at the time that the USTR received over 35,000 public comments, thousands of American businesses begging for exemptions, citing the fact that they literally could not survive the price hikes. The USTR ignored them. They didn't just ignore them, they didn't even acknowledge the substance of the complaints. They argued that because this was a matter of foreign policy and national security, the Administrative Procedure Act, the law that says the government has to actually listen to the people it's taxing, didn't apply. That was the first domino. The second domino fell when the litigation began. 6,500 companies filed suit, arguing that the government had overstepped its statutory authority. This wasn't a fringe movement of activists. This was the backbone of the American consumer economy. The Wall Street Journal noted that the government's defense rested on a single shaky premise. The president can do whatever he wants in a trade war, but the courts are now signaling that this is not how the math works. The government collected $166 billion in revenue from these specific tariff tranches. That money has already been spent. It's gone. It's vanished into the federal deficit. And yet the Court of International Trade and now the higher appellate courts are looking at the data and seeing a procedural void. They are seeing a government that skipped the math to get to the headlines. Now we have to look at the economic math. This is where most analysis stops, but we are going to go deeper. We need to break this $166 billion impact into its core components. Component 1, the refund liability. If the Supreme Court or the Federal Circuit finds that the List 3 and List 4A tariffs were procedurally invalid, the U.S. Treasury doesn't just stop collecting them, they owe the money back with interest. Institutional sources like the Congressional Research Service have hinted that the interest alone could add billions to the total. Translation: Every dollar you paid more for a household appliance since 2019 was essentially an illegal tax that the government now has to find a way to repay while already running a $1.7 trillion deficit. Component 2, the inflationary snapback. The mainstream media told you tariffs were paid by China. They were wrong. Every study from the National Bureau of Economic Research to the Federal Reserve Bank of New York has confirmed that 100% of these costs were borne by U.S. importers. If those tariffs are struck down, the price of goods should theoretically drop, but the sudden liquidity injection of $166 billion back into corporate coffers while the Fed is trying to cool the economy would be a chaotic inflationary signal. Component 3, the revenue black hole. Customs and Border Protection data shows that tariffs have become one of the few growing revenue streams for the federal government. Take that away, and the fiscal gap widens overnight. Add the $166 billion refund to the projected $300 billion in lost future revenue over the next decade, and you are looking at a $500 billion hole in the American budget. Stop. Let that land. The very mechanism designed to strengthen the American economy has become a $500 billion liability. Behind closed doors, the atmosphere is electric with panic. Take yourself inside the USTR headquarters and the Department of Justice. There are two camps. Camp A, the hardliners, are pushing the political question doctrine. They are telling the judges that if the court interferes with tariffs, they are interfering with the president's ability to conduct a war, even an economic one. Camp B, the pragmatists inside the Treasury, are terrified. They know that if the court rules against the government, the precedent is set. It means any future president, Trump, Biden, or anyone else, cannot use trade as a blunt force instrument without a grueling, years-long administrative process. As one former senior trade official privately admitted to Reuters, if we lose this, the trade war is over because we've lost the element of surprise. We can't move faster than the courts. This is the hidden reality. The America First strategy relied on the idea of the madman theory, the ability to levy a 25% tax on $200 billion of goods over a weekend. The courts are about to say, no, you have to show your work. You have to prove the math. You have to respond to every single one of those 35,000 businesses you ignored. The consequences now begin to cascade. If you are a small business owner in Ohio or a retail manager in Florida, you have been operating on margins that were squeezed by these tariffs for 5 years. If this court ruling goes against the government, the two-path scenario becomes your daily reality. But before we get to those paths, consider the second-order effects. The shipping industry, already reeling from Red Sea disruptions and Panama Canal droughts, would see a massive unregulated surge in volume as companies try to front-run the legislative chaos. Geopolitically, China is watching this court case more closely than any election. If the U.S. judiciary breaks the trade war, Beijing wins without firing a single shot or making a single concession. They realize that the American system of checks and balances is effectively dismantling its own weapons. If this analysis is making sense to you, hit like. It helps the algorithm push this data past the surface-level noise of the 24-hour news cycle. We are now facing two distinct paths. Path 1, the judicial reset. The Supreme Court validates the lower court's concerns, stays the collection of tariffs, and orders a mass refund process. This would be a victory for the rule of law, but a catastrophe for the U.S. Treasury. It would signal to the world that the U.S. cannot maintain a consistent trade policy across presidential administrations. It would trigger a massive rally in retail stocks, but a devastating blow to the domestic manufacturers who were promised protection and are now left exposed to cheaper imports. Path 2, the spiral. The government, desperate to keep the $166 billion, attempts to redo the administrative process retroactively. This would create a secondary legal nightmare, tying up the American trade system in litigation for another decade. During this time, investment stalls. Nobody builds a factory in South Carolina or Michigan if they don't know what the price of steel or components will be in 6 months. The uncertainty becomes a tax of its own, a chaos premium that every American family pays for at the grocery store and the car dealership. The single variable you cannot control is the timing. The courts move at their own pace, indifferent to election cycles or market volatility. This is where we stand. What the mainstream media is going to tell you is that this is a story about corporate greed or political maneuvering. They are wrong. What we are actually witnessing is a structural transformation of how power is exercised in the 21st century. We are seeing the limits of the imperial presidency meeting the cold reality of the Administrative Procedure Act. The $166 billion isn't just a number, it is a symbol of a government that tried to bypass the math and got caught. If you are a worker in a factory that was supposed to be protected by these tariffs, you have to ask yourself, was the protection real if it was built on a legal foundation of sand? If you are a consumer who has watched prices climb, you have to ask, was it worth it if the money we paid is now being handed back to the very corporations who passed the costs on to us in the first place? This is not a partisan issue. This is a structural failure. The trade war wasn't broken by an external enemy. It was broken from within by a failure to follow the very rules that make the American system unique. The $166 billion warning has been issued. The question is whether anyone in Washington is capable of hearing it before the check comes due. I want to hear from you. Do you believe the U.S. government should be forced to refund this money, even if it means a massive hit to the federal budget? Or should national security override the procedural rights of businesses? I read every single comment. This is Daily Brief. Subscribe if you haven't. The story isn't over, it's barely begun.